Hello, everybody. My name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. I want to welcome you all here today and thank you for coming. We appreciate you taking this time off in the middle of your day to learn about HOA living and the laws and requirements of the HOA management. So thank you for participating in this community conversation. Conflict resolution through mediation, arbitration, and ADR, IDR. That's alternative dispute resolution and internal dispute resolution. ECHO is a 50-year-old statewide nonprofit association supported to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on your screen. The slide was sent to all registered attendees in advance, so you should have it. Please take a moment to review our housekeeping items and please stay in the confines of those housekeeping rules. Today, we have a large audience of HOA board members and homeowners. We will do our best to answer your questions, but we may run out of time. At the prerogative of the presenters, some questions will be answered during the presentation or only during the question and answer period. To answer as many questions as possible, I may answer some of your questions as long as I feel comfortable answering those questions. So we will be answering those, as many as possible. We will do our best to respond to all questions by the close of the webinar. We use the voting feature during the Q&A to prioritize questions. Simply vote for your favorite question by using the thumbs up icon. It's a little button on the bottom left of your screen, I believe. And the questions will, with the most thumbs up votes, will receive priority. Also, please keep your questions general in nature and short. We may pass over some of the questions that are too long or too specific. Questions about your community are best asked of your attorney or another appropriate expert familiar with your situation. Please use the chat feature to report any technical issues and to communicate directly with other participants in the webinar. Again, I'm going to add to that and repeat that is that the chat feature is for technical issues and to talk to each other, sort of direct messaging. And we'll use the Q&A feature to ask your questions. That way we can record the Q&A, the questions that you do ask. Now let's review our disclaimer for this presentation. I direct your attention to your screens. None of what is said during this seminar shall be construed as specific legal or expert advice from the speakers, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you. This webinar and all ECHO events are made possible by the generous support of ECHO HOA professional service providers. Join me in thanking them today. Our program sponsor is Silver Creek Association Management, and our registration sponsors are George Peterson Insurance Agency and the Levy Erlinger and Company LLP CPAs. We will now hear a brief word from Laura Ravazza with Silver Creek Association Manager. Connor?
Hi, I'm Laura Ravazza with Silver Creek Association Management. Our core mission at Silver Creek and the touchstone of everything we do is to manage communities with its people in mind. That means we don't just aim to check off standard management boxes, but to listen and cater to the unique individual needs of each and every member of a community. We believe in enhancing the livelihood of communities through our unparalleled dedication to customer service, our ability to offer professional expertise in all areas of HOA management, and our tireless drive to ensure that the communities we take care of are heard, happy, safe, and thriving. We aim to consistently go above and beyond the confines of typical HOA management duties. It's because we genuinely care about how your community functions. We understand that managing a community can be a demanding responsibility, but our team of experts understands how to get things done with efficiency and finesse. Please let us know how we can help you and your community. I hope you have a great education workshop today.
So thank you so much for that, Laura. I want to say thank you to everyone here today, and please support all ECHO professional members and especially our sponsors of today's presentation. They make our educational program possible at little or no cost to you. And now I'd like to turn our program over to Jonathan and give him a brief introduction. Jonathan Caton is an attorney on a mission to help HOAs and homeowners avoid the judicial system and resolve conflicts expeditiously and inexpensively as possible. John is based out of Irvine, California, and his background includes extensive experience mediating disputes as well as representing individuals, corporations, and public entities in litigation and pre-litigation in a wide variety of practice areas. As a former prosecutor for one of the largest municipalities in California, John has significant experience as a trial attorney and appellate advocate representing public entities and individuals. John is also an adjunct lecturer at the Dale E. Fowler School of Law at Chapman University, where he coaches trial advocacy, appellate advocacy, and mediation competition teams. He also serves on the Riverside Superior Court mediation panel. Welcome today, Jonathan, and please go ahead and begin your program.
Thank you, David. Much appreciated. Thank you, David. Much appreciated. Looks like we have quite a few folks today who want to learn about conflict resolution, and that makes me both happy and sad. But let's see if we can't quickly go through some of the procedures that most California homeowners, HOA boards, and even vendors can expect to go through when they have conflict in their communities. And I'm going to try and do my best to give everyone an overview of what is unfortunately considered alternative dispute resolution. Because frankly, in the United States of America, primary dispute resolution is performed in the courts. And that's something I'd like to see change significantly. So Connor, can I have the next slide? Always have to start off a presentation with a quote, and this is one of my favorites from the great Mr. Lincoln. I spend most of my time trying to keep people out of the courtroom, and it is inevitable. Sometimes being in court is necessary, but I'm hopeful that after this presentation today, everyone will have a little bit more of a reasonable perspective about what it takes to go to court and the benefits and detriments of doing so. Can I have the next slide, Connor? So the adversarial court system, what are you set up for in the good old US of A when it comes to resolving a dispute in a court of law? It's definitely not straightforward. It is definitely time consuming and it is definitely expensive, but this is the primary form of dispute resolution in our country. You have two people who have a problem and they want to take it to a judge or a jury and have that judge or jury decide who is wrong and who is right. And that is primary dispute resolution in our country. Can I have the next slide, Connor? And it seems silly, but I've had to explain this to more than one attorney, that conflict resolution, the way that we do it typically really lies in the courts. You've got advocates, attorneys who represent parties' legal positions, and they ask a theoretically impartial person or group of people to literally pass judgment on who is right and who is wrong. That is American dispute resolution, primarily speaking. Next slide, Connor. But courts are extremely limited in what they can do, okay? And I can't stress this enough. If you go into a court of law in the United States, chances are whatever your problem is, or whatever your neighbor's problem is, it's going to be reduced to a dollar amount. There are very few things in the legal system that are not reduced to money. And unfortunately, that means money drives most of what goes on in and outside of a courtroom. And that comes down, unfortunately, as we'll discuss a little bit later, into heavy play in HOA disputes, because not only is money the way that a person is going to be compensated for a problem in most circumstances, but HOA disputes in California have what's called a fee shifting statute that gets applied to a large number. And you have a fee shifting statute. That means that the winning side, whoever the court or jury determines to be the victor, can ask for their attorney's fees to be repaid by the other side. And that makes things extra messy and extra lengthy. Next slide, Connor. And the court system gets even more problematic than that. I mean, one of the fundamental things that I think most folks need to take into consideration before they ever think about filing a lawsuit is that once you're in the court, you cannot control the outcome. You're asking people to decide whether you are right or wrong. And sometimes courts won't even give you that clean cut of an answer. Attorneys will frequently talk about judges or juries splitting the baby and deciding that people are right in some ways and wrong in others. But when you're in that system, once you filed a lawsuit, you're asking for that judge or jury to render a verdict, to give you that answer. And that requires you to go through a system that has tons of rules that can be daunting even for attorneys, frankly. The California list of various legal rules, whether it be evidence or civil or criminal procedure or appellate procedure. I mean, we're talking books that stacked one on top of another reach many feet high in this day and age. It's a lot, and that unfortunately, again, makes it very expensive. It's also extremely time consuming, and especially in a post-COVID world, it is not unreasonable to expect a case to take 2 years to get from the point of filing the lawsuit and letting the court know that you have a claim to actually getting the guts of the matter in front of a judge or jury. And I've already discussed and will continue to repeat, it is extremely expensive. It is not unreasonable for lawsuits to cost hundreds of thousands of dollars just in attorney's fees in this day and age. Have the next slide, Connor. And there are even more good reasons to avoid lawsuits, at least from my perspective. When you are trying to actually plead a case in front of a judge or a jury, and it can be pleading your case in writing, it can be having your attorney get up and give an opening statement or a closing argument in a trial, there are going to be limitations on how much of your story can be told, what sort of evidence you can present, what the judge or jury can actually literally hear, and how much they can actually take into consideration if the evidence that you want to present is even allowed in court. Those wonderful, daunting legal rules have many, many hurdles that can present themselves at various stages of a case that will limit how much of your story can be told. And courts do their best to drill down on the nitty-gritty of a dispute. What is it that we're actually here to argue about? What is the crux of the dispute? But often disputes go well beyond the actual legal definition that a court will allow a judge or a jury to interpret. Particularly when it comes to HOA disputes, you can have folks who have been having a dispute fester for decades before they actually have the proverbial straw that breaks the camel's back that drags them into a courtroom. And a lot of those things that are decades old are simply not going to make their way in front of a jury a lot of the time. They're not going to be things that a judge will allow someone to consider when it comes to determining the real guts of the issue. So you have to accept the fact that that impartial judge or that impartial jury will never really know your lived experience. They'll never know what you're going through and what you have gone through. Not only are they a different person, but there's just too many rules in place that will limit what they can hear. Have the next slide, Connor. And I went ahead and I pulled one of about 1,000 different rules of evidence that juries actually get instructions on when they are getting ready to decide a verdict in a trial. If you've ever had the pleasure of sitting on a jury, you may have seen something like this, but jurors are literally read by the judge and then handed pages like the one in front of you right now that instructs them on the law, what they can and cannot consider. And this is just one, it's the 200 series, as we call it. There are series that go up to the 5,000 in numbering, if that gives you any indication of how many different rules there are that jurors can potentially be instructed on. But this particular instruction is short and sweet, and it's just an excerpt. But it demonstrates that there are things that can happen during a trial that a jury may even hear that they are instructed they can only use for a particular purpose, and they're not supposed to use it for any other purpose. These are the sorts of things that you have to contend with when you are filing a lawsuit, assuming that you get to trial within that 2-year time frame. Can I have the next slide, Connor? And not to, make everyone completely depressed at the beginning, but I like to start off with the bad stuff and then go toward the bright shining light at the end of the tunnel, which I promise we will get to in a few slides. But these sorts of court battles are unfortunately not uncommon. And a lot of the California rules for HOA dispute resolution actually started to germinate when it became clear that folks in HOAs had disputes that could take years to get through the court system, and thousands of dollars in attorney's fees just over a single CC&R clause. And still to this day, there are cases like that that make their way through the court system. And my favorite example, because it's a very interesting case, and also because it's something that everyone can look up if they want to see how long this process can actually take, is a case called One Ford Road, and that's the Homeowners Association versus Johnson. And this case is far more complex than I'm going to lay out here, but simple crux of the dispute is a homeowner wants to renovate their house. So they do all their applications, their paperwork, pay their deposits, and they do their renovation, and then they submit their notice of completion to the HOA. And that's where things get interesting. Next slide, Connor. Now, looks like we're on a bit of a delay here. So after the renovation, the HOA wants to perform a final inspection. And you can just keep clicking through, Connor, because I think it's on a delay. But when the HOA wants to perform their final inspection, there is some confusion about who is going to perform that inspection. Is it going to be a member of the HOA board, or is it going to be a private architect who is going to conduct this inspection on behalf of the HOA board or under contract from them? And for a number of different reasons, the parties can't come to any sort of resolution, as silly as it may seem. So they end up in court. And a 4-year court battle, yes, this took 4 years to wind its way through the system, all came down to the little sentence in quotation marks underneath the house on this slide. The homeowners did not refuse access for inspection within the meaning of the CC&Rs. That is the language that the Court of Appeal eventually focused on. But the thing that makes this case so important from my perspective is that the homeowners in this case spent over $300,000 on attorneys just to get to the point of having a Court of Appeal say, you did not unreasonably refuse access. This case is so illustrative on a number of different levels, because the amount of money that was in dispute was about $5,500. The language that was in dispute was fairly clear cut. But the parties simply could not agree on who was wrong. I mean, that's what it really came down to. The HOA said that the homeowners didn't allow inspection within the time frame allowed by the CC&Rs. And the homeowners said that the HOA didn't perform their inspection within the time frame allowed in the CC&Rs. And to me, that's an incredibly silly reason to spend hundreds of thousands of dollars. But these are the sorts of disputes that will inevitably make their way through the court system if your community doesn't have a robust dispute resolution mechanism. Can I have the next slide, Connor? So California's alternatives to litigation, and in a couple of slides, you'll see that I don't consider these alternatives at all. These should be your primary forms of dispute resolution if you actually have a grievance. But they can be broken down into what is called internal dispute resolution or alternative dispute resolution. And there are two different mechanisms. These are differentiated under California law. And there's a funny reason why that exists, but you technically have two different ways that you can resolve disputes when they come to a head in your community. And there's even more alternatives than that, but these are the ones enumerated under the law. Can I have the next slide, Connor? So, yes, California does have two different dispute resolution procedures. And this all goes back about 30 years, but in about 1993, ADR, alternative dispute resolution, was mandated because a few very logical and reasonable people saw that HOA disputes were becoming a big problem. There were a lot of them making their way into the court system, and they were getting very expensive. In about 1990, the fee shifting statute that I mentioned earlier that allowed a winning party to request reimbursement of attorney's fees, that went into effect. And all of a sudden you had HOA cases that were becoming very, very problematic. So alternative dispute resolution is ordered in about 1993. But that doesn't solve the problem. There's still a lot of HOA cases that continue to make their way through the court system. So IDR is added as an initial step towards dispute resolution in about 2004. And it's been that way ever since. With the hope that internal dispute resolution would encourage communication within the HOA itself, sort of an internal process that wasn't going to drag in folks from outside the community, that would allow disputes to be resolved. So hopefully they didn't even get to that stage of the ADR process. Because funnily enough, ADR becomes a prerequisite for filing a lawsuit in lots of HOA cases. So that IDR procedure is supposed to be there to help people avoid getting on the cusp of filing a lawsuit to begin with. Can I have the next slide, Connor? And there are actually some specific definitions, and I encourage anyone who wants to know more about this subject to go to davissterling.com, because the Davis-Sterling Act is the sort of body of California HOA law. And there's actually a website called Adam Sterling that publishes pretty much all of the current legislation and statutes and even court cases that will affect HOAs. But according to the Davis-Sterling Act, alternative dispute resolution, or ADR, can include mediation, arbitration, and conciliation, right? And like I said earlier, for many HOA disputes, you have to attempt ADR before you even file a lawsuit. And if you don't attempt ADR, then that can affect your ability to, number one, prevail, and number two, to request recovery of your attorney's fees from the losing side. Can I have the next slide, Connor? IDR is a little bit looser in terms of its definitions. The way that California law lays it out, IDR should be a fair, reasonable, and expeditious procedure. It doesn't mandate mediation. It doesn't mandate arbitration or conciliation. It's really supposed to be a mechanism where HOA boards and community members can have a formal opportunity to meet with each other and discuss a dispute with the hope of resolving it internally. The statute does encourage the use of third-party neutrals, though. And you'll hear me use the word neutral a lot. And all I'm saying when I use the word neutral is someone who does not have a vested interest in the outcome of the dispute. They're not representing either party. They are not a member of the community. They have no dog in the fight. And in the legal context, neutrals are usually going to make their appearance in the form of a mediator, someone who can try and step in and help the parties reach a resolution. For the purposes of IDR, you don't have to use a neutral, but it is encouraged, and it's actually within the statute that they strongly encourage the use of mediators. But most HOAs, they just go with the minimum requirement, which is this meet and confer, sort of hold a meeting or exchange in a letter writing campaign what the dispute is about and whether or not that dispute can be resolved without going any further. That's the minimum that HOAs have to do. And that's what most HOAs rely on because mediators are going to cost money. Lots of HOAs don't want to get into a situation where they're paying for a mediator to help resolve a dispute, particularly if they don't think that litigation is a serious threat. Can I have the next slide, Connor? So why does this matter? To me, this matters because most disputes that actually make their way to mediation, at least in the current day and age, have been allowed to come to a head. There's a dispute that's been festering, and the only reason why it's gone to ADR is because it hasn't been properly addressed. But by the time it makes it to that level, parties are probably thinking about filing a lawsuit. They're getting to the point where they're frustrated enough that there has either been inaction or there has been, complete ignorance or unawareness of the problem, that they're starting to think, maybe I need to file a lawsuit. And hey, ADR is a prerequisite for filing a lawsuit, so I guess we're going to attempt ADR. And that overly simplistic summary of the thought process still seems to hold true in a large number of cases. So by that point, parties are starting to think about hiring attorneys, and then they're going to start spending big money because attorneys are expensive. And at that point, lawsuits can almost become inevitable, because once someone has started investing in the potential for a lawsuit, and once they hear that there's the possibility that if they win, they might be able to get their attorney's fees back, even though winning in a lawsuit is absolutely incapable of being guaranteed, they still sort of cling to that hope, like a lottery ticket in the court system, that maybe if I take this to its ultimate conclusion, I can get my attorney's fees paid back. And that's a very dangerous road to hoe. Can I have the next slide, Connor? So my goal in pretty much every aspect of my life, whether it's law related or HOA related, or even in my own home, is to take the alternative out of alternative dispute resolution. It is, in my opinion, that what we should really be trying to encourage communities to do, particularly in the context of HOAs, is to use the alternative to the court system as their primary mechanism for dispute resolution. Don't allow problems to come to a head. Don't allow them to fester. Don't feign ignorance or even just take literally the path of ignorance and try and ignore problems. Try and address them. Try and do your best to keep your community harmonious by not allowing these things to, for lack of a better term, take control of your community. Because once a lawsuit is filed, it really has a lot of cascading effects, and the fallout can be considerable. Can I have the next slide, Connor? So, as I've already said, these should not be alternatives. These should be your primary forms of dispute resolution, and filing a lawsuit should be a last resort. And a lawsuit is not something that should be taken off the table. I don't mean to tell anyone that lawsuits are completely outside the boundaries of reason, because it does help to have the court system there as sort of the ultimate threat. to say, look, if we can't resolve this amicably, we're all going to spend a lot of time and money fighting about this in a court of law. And that's still a good thing to sort of keep everybody in check, to make sure that nobody is capable of literally feigning ignorance and not doing anything to address problems in their community. Can I have the next slide, Connor? So negotiation is not something that's on the title of this presentation, but it is something that is literally a component of every facet of life. So I want to go through the basic fundamental negotiation principles, because whether you're in mediation or whether you're engaged in a lawsuit or whether you're just arguing with a neighbor or a board member or a vendor, negotiation is something that you can use to help you resolve disputes before they even become disputes. And that's worthwhile. Can I have the next slide, Connor? So the first negotiation strategy, and these are all very broad, and I will give everyone a recommendation for a book that I think lays out a lot of these ideas and principles in a practically applicable way in a few slides. But there are a number of different ways that you can generally approach a negotiation. And the first general approach is competing. And this is kind of your used car dealer style of negotiation. You want to get the best deal you can on the car, and the car dealer wants to take as much money from you as possible. Leverage every conceivable opportunity, point out nicks and scratches in the paint job, the mileage on the car. Do everything you can to leverage your position as best possible. And in a car dealer sort of situation, that's not a terrible idea, because you're probably never going to see that car dealer again. But this is a terrible strategy to employ in any sort of situation where you want to foster or where you will need to foster a long-term relationship. If parties have a competing negotiation attitude, they will never really be able to develop that trust and maintain community harmony. So from my perspective, competition in HOAs should be pushed to the side immediately. Next slide, Connor. The opposite view, and the thing that I think is most appropriate for HOAs, is called collaboration or collaborating mentality. It's the exact opposite of a competitive style. And it really does focus on getting a win-win because it encourages teamwork. And a lot of people will think that compromising in a negotiation is an effort to get a win-win. I don't see it that way. Compromising, you're giving up something in order to get something from the other side. And there's nothing wrong with that. Compromising is perfectly appropriate as well. But if you can engage in a truly collaborative negotiation, if you can accept the fact that your HOA board is there to try and help your community, and your HOA board can accept the fact that if you're coming to them, you probably have a legitimate grievance, and you probably have a legitimate reason for coming to them, then in all hopefulness, you will be able to collaborate and find a resolution to a problem that will encourage everyone to work for the benefit of everyone else. That's exactly what an HOA is supposed to be. So this is my preferred mechanism for negotiating, or heck, even mediating an HOA dispute. Can I have the next slide, Connor? Compromising, as I alluded to earlier, giving up some of your position to get something else out of the situation. And hopefully this ends on terms that feel good for everyone involved. The cynical way to look at it is that everyone ends up with a resolution that they can be equally miserable with. And cynical attorneys and judges will frequently refer to a compromise as being just that. Nobody's truly happy, but everyone is happy enough that they can walk away from the situation without escalating it further. And to the last point on the slide, compromise will hopefully provide everyone with a solution they can live with at the very least. Can I have the next slide, Connor? Avoiding, strangely enough, is absolutely a tactic that I have seen, and I will probably continue to see in HOA disputes. And it can be used either with ignorance or deliberately. But this can actually be a negotiation tactic, crazily enough, to just ignore the dispute, to avoid actually addressing the problem, the complaint, the criticism. It's terrible for HOAs because ultimately everybody ends up feeling frustrated and betrayed. There's no ability for a homeowner or even an HOA board or a vendor to really feel like they can trust that the other person is coming to the table with good intentions if someone is using an avoiding negotiation strategy. And I mean, worst case scenario, the other side thinks they're being manipulated, that there is a deliberate strategic purpose behind the avoiding sort of attitude. And then people get really ticked off and then they want to go to court. So stay away from that one as a tactic. Next slide, Connor. Accommodating is probably the strategy that is utilized most often by HOA members. And there are, heck, you can probably even see in most of your communities, there's a level of disengagement from a lot of folks that live in an HOA. It's literally, keep your head in the sand, worst case scenario, but at the very least, keep it down. Don't put yourself in a position where you're skylining yourself and you're, verbally or in writing, airing a grievance to the board, because then you're going to be spotlighted. So just do what you're told. Just go ahead and accommodate whatever requests are made of you. Do whatever your neighbor wants. Do whatever your board wants. Do whatever your contractor wants. But that can backfire because everyone has a breaking point. Everyone has a moment where they're going to say, you know what, I've had enough. I have gotten to a point where I feel like I've given and I've given and I've given, and I'm paying hundreds of dollars in dues every month to this HOA. When am I going to get something back? And the point being is that problems will fester, even if you're trying to accommodate someone as a routine negotiating strategy. And when you hit that point where you just can't take it anymore, again, you tend to say, all right, I guess I've got to go to court. I guess I have to go ahead and go to the nth degree and file a lawsuit because I simply can't take this anymore. Can I have the next slide, Connor? And this is the book that I was mentioning earlier. There are lots of negotiation books that are out there. This is my favorite. It may probably be largely related to the fact it was written by an ex-FBI agent, and I have a military background, so I like the way that he speaks. But he does a very good job of analyzing a lot of the old negotiation texts and styles and kind of bringing them up to date, and giving everyone the ability to really utilize negotiation tactics for a positive purpose, even though the title doesn't necessarily make that clear. It's an excellent book and an excellent resource if anybody wants to learn more about negotiation. Can't recommend it highly enough. Can I have the next slide, Connor? So let's just, I guess, pretend like we have a real life dispute and our efforts at negotiation for whatever reason have failed. The next logical step that you will probably end up taking is some form of mediation, where you get that third party neutral involved to try and help the parties work out the dispute still amongst themselves, but kind of guide them through a structured negotiation, or help them perhaps look at the positives and negatives of whatever their particular strategy for addressing the grievance may happen to be. Help them understand the positives and negatives of actually going to court, and help facilitate a conversation that will still give the parties control over the resolution, but will do so with that guidance and assistance that can frankly be rather critical when you have an HOA board and a member or two HOA members who are just at loggerheads and simply cannot find a way to talk amongst themselves without having a mediator present. And amazingly enough, there are various mediation styles, and I have my own criticisms about how those mediation styles tend to be employed through lots of professional mediation services, because so few of them are really focused on HOAs. And HOA disputes, in my opinion, are unique and require a little bit more attention than the average lawsuit. But let's go through a few of them. Can I have the next slide, Connor? So 4 basic mediation styles, and they can get broken down in even more detail, and I will in just a second. But facilitative mediation is the most common form of mediation style. Evaluative, unfortunately, tends to be the mediation style that gets employed when parties are considering a lawsuit or engaged in a lawsuit. And transactional, to skip that transformational bit, transactional mediation is literally shuttle diplomacy, trying to go ahead and get the parties to sign on the dotted line and actually negotiate a transaction. There are mediators who do that. But for the purposes of HOAs, transformational mediation is the one that I think can be the most productive and certainly the most satisfying. Can I have the next slide, Connor? So for a facilitative mediation, you're generally going through and doing what I just described. You're helping the parties try and understand, hopefully, the perspective of the opposing party, but at the same time, understanding their own goals and interests. A mediator is not supposed to make recommendations or impose decisions, although I have seen it happen, unfortunately. But they are supposed to try and encourage the parties to think in a little bit more broad perspective. Folks can have a tendency, obviously, to really narrowly or myopically focus on a particular problem and not think about the potential fallout and consequences, for example, for the rest of their community if they have to file a lawsuit. And mediators can help in a facilitative sort of fashion, help the parties ponder those different things. What are the secondary implications of allowing this dispute to continue? But hopefully they allow the parties, again, to work out a resolution that the parties have effectively crafted themselves. And one of the things that I love about mediation is that it is literally an opportunity for the parties, the people who are actually engaged in the dispute, to craft their own resolution. You can come up with solutions that a court could never offer you, that a judge or a jury could never offer you because of the boundaries of the law. You can come up with all kinds of creative ways to solve a dispute and even prevent future disputes from occurring using mediation. Can I have the next slide, Connor? An evaluative mediation style is unfortunately something I see far more commonly in HOA disputes, because you have the vast majority of dispute resolution services these days being occupied by retired judges. And that's not to criticize retired judges. They know what they're doing, but they're also very used to rendering judgment. So instead of focusing on underlying goals and interests, they tend to be very heavy on giving people an evaluation of the legal merits of a dispute. And that can be very, very helpful. Don't get me wrong, because if you bring a dispute in front of a mediator and he says it doesn't have a hope or a prayer of succeeding in court, it's probably worth pondering whether or not litigation is really something that you want to continue thinking about. But it also has the unfortunate likelihood of, again, reducing everything to a dollar amount. Judges are used to trying to figure out how much a case should be worth. And if they fall into that trap and they don't hold on to enough of the facilitative negotiation style, then they can ultimately and overly simplistically say, what's it going to take? How much is it going to take in order to get this dispute resolved? And that doesn't solve a lot of problems, because very rarely, as I think I've made clear at this point, can an HOA dispute truly be reduced to a dollar value. Can I have the next slide, Connor? Transformative mediation, my favorite for HOAs, because again, it focuses on the notion of collaboration. In all hopefulness, a transformative mediation will literally change the parties' perspectives. It will give them not just the ability to consider the other party's position, but to literally consider how they can help the other party achieve their goals. My wife happens to be a family law attorney. And if you can achieve a transformative mediation in a family law context, it's fantastic. And it's something that absolutely needs to be employed more often in HOA disputes, because you are going to be hanging around these people for an awful long time in most situations. You are not going to, hopefully be considering selling your house in order to avoid having a dispute with the irritating neighbor in the future. Hopefully you will be trying to foster a community that will help you benefit everyone else in the community. And from the perspective of HOA boards, there are very often recommendations, and you can even call them complaints or grievances, that you will get from a member that, if you think about them and you really ponder where that member is coming from, can help you be a better board and can help you govern more effectively and can put you in a position to have a better HOA. But you've got to not only think about the other party's perspective, but you've really got to try and see if there's a way for you to have that collaborative relationship moving forward. Can I have the next slide, Connor? Transactional mediation, short and sweet. Get an agreement. That's literally the only purpose of it. If you have managed to go ahead and get yourself 9/10 of the way to a resolution, a transactional mediator can probably help you, edit and redline those last few bits of the agreement and just get everybody to go away. It doesn't have a tremendous amount of applicability in HOA disputes unless you're talking about a dispute between a vendor and an HOA. It really tends to reduce things to monetary value. Can I have the next slide, Connor? All right. So mediation, the first alternative dispute resolution mechanism in HOAs. Those are the four basic things that you might see if you get to a point where you actually have to consider making a demand of a member or your HOA board or even a neighbor if you want to engage in ADR as it's defined in California. But strangely enough, you don't have to go to mediation in order to satisfy the requirements of ADR under California law. You can go to arbitration, which is kind of funny to me because arbitration is not that much different from litigation. Can I have the next slide, Connor? It's basically like hiring a private judge. It's still an adversarial system. And if you're going to go through arbitration, you're probably going to have an attorney. It doesn't have to be that way. And I'm a big fan of setups that allow folks to arbitrate without having to go through the cost and expense of hiring legal counsel. But I honestly have never seen an American system where that happens. It is usually going to drag attorneys into the mix, and it's going to get expensive, and it's going to be very similar to going to court. But it is still far more efficient and flexible and far less formal than actually going through a lawsuit. And the biggest reason why it has advantages is because you get to set the timetable. You don't have to wait for the next available slot on a judge's docket to actually get your case to trial. Can I have the next slide, Connor? But it's not perfect. And I think I've already done enough throat clearing about that. Because it is more informal and flexible, it can still be unpredictable And you do have to have everyone agree to participate in an arbitration. It's a voluntary process. And I should have said it before, mediation is the exact same way. Under alternative dispute resolution in California, once you make an ADR demand, it really behooves the other party to seriously consider it, because if the other party rejects ADR, there can be consequences. But in the context of arbitration, it usually is not employed for ADR, at least within the definition of ADR in California law, because it is so akin to litigation. But probably the thing that is least commonly discussed and most obvious to attorneys, but not obvious to everyone else, is there's no jury in an arbitration. It's very similar to a bench trial. Best case scenario, you have a panel of 3 arbitrators deciding an issue, but you're paying all 3 of those arbitrators if you actually want 3 people to weigh in on the subject. So most people just have a single private judge that they hire for an arbitration. It's like a bench trial in court, because that is an option too. Not every case goes in front of a jury. Sometimes you have a judge deciding the issues. Oh, I will say one more thing, because I have seen lots of CC&Rs, especially recent ones, where arbitration is something that is built in. So if you do live in a fairly new community, it is worth looking at your CC&Rs and seeing if there is a mandatory arbitration clause that's part of them, because you may, even if you go to mediation, you may end up going before an arbitrator in order to actually adjudicate the merits of the dispute, meaning you may go in front of an arbitrator instead of going into a traditional lawsuit in court. Can I have the next slide, Connor? And that's important because arbitration can be binding or non-binding. If you have binding arbitration, it is final. It is literally enforceable. Like, you can take an arbitration decision and you can appeal it if you want to, but the opportunity to appeal an arbitration decision is so incredibly narrow that it is pretty much one and done. that arbitrator's decision is going to hold water at 99 times out of 100. Non-binding arbitration is, strangely enough, a possibility. If you just want to explore the merits of a dispute and get a little sort of cue on whether or not your case might have a chance of succeeding in court, you could, in theory, go to non-binding arbitration, but you're going to end up paying for that private judge, and that's going to get expensive. And there's no enforceability for it. So it's very rarely employed, especially since expenses can rack up so quickly. When you get attorneys involved, it gets particularly expensive. Can I have the next slide, Connor? And there is another option out there that has been employed by about 7 states up to this point, not in the way that I think it should be employed, but there is something called an HOA ombudsman that is a concept, and it's worth exploring because California has actually tried to pass legislation on this about 3 times in the recent past, and it may come up in the future again. Next slide, Connor. Historically, ombuds are literally like government oversight officials. Ombudsman is a Swedish word, and you literally had sort of the check and balance of government through the ombudsman, who could provide oversight of government officials. In the modern context, and particularly in the United States, this has been reduced to what's called an organizational ombudsman. It's the most common format for it now, where you literally have a neutral person that's kind of embedded in the organization who can help resolve issues and be a communication mechanism for private corporations, colleges, nonprofits, even communities. Can I have the next slide, Connor? And this actually has a lot of merit to it, because if an ombudsman system is set up properly, you literally have an independent, impartial, informal, and confidential resource for the community, whether it be an individual member or an HOA board or even an outside vendor, to use to address conflicts before they even really become conflicts. If there's something wacky that goes on in the community, in theory, you can have informal investigations conducted. And most importantly, that ombudsman, because they don't have a dog in the fight, can hopefully help brainstorm solutions and get everyone to that collaborative negotiation process or transformative mediation a little bit more quickly. Can I have the next slide, Connor? It's literally designed to sort of be an internal resolution channel, and they're not supposed to represent anyone. They're just supposed to listen objectively and give unbiased feedback. They can even provide shuttle diplomacy and informal mediation. But if you look at the way that this name has been applied to the various different states that have passed ombudsman statutes, it really hasn't materialized in this fashion. Lots of states have tried to kind of hybridize the ombudsman idea, and you end up having a complaint department when it's run by the government, someone who's less than effectual. So I'm a big fan of encouraging HOAs, property managers to set up their own independent ombudsman, someone who can actually operate within their individual communities instead of being a government-run oversight entity. Like in California, God help me, the millions of people that live in HOAs that could potentially have a grievance. I have very little confidence that anything would be done on the state level that would actually help resolve disputes, but I might be a little bit cynical. Next slide, Connor. So I'm actually almost at the end. And I know I've thrown a lot at everyone, but I've managed to cram that all into about 57 minutes. So I feel like I've done something good there. But what do I want everyone to take away from this? Number one, I hope that everyone will encourage their community members to listen to one another. Having an open ear and an open mind will help you go far, whether that's in the context of a collaborative negotiation or mediation. Listening to what the members of your community have to say can actually do a lot to stave off problems. Hosting dispute resolution training and workshops and actually training members of your community how your system and your process works will also be very, very helpful. Before you do that, you should probably have a procedure set up that you can actually train your community members on. But if you can, setting up a procedure that utilizes trained third-party neutrals, whether they be professional mediators or other dispute resolution professionals, can help take a little bit of the adversarial nature of a neighbor or HOA relationship out of the mix. When you have someone who has no dog in the fight, people tend to listen to them a little bit more receptively. And finding a neutral that can actually get to know your HOA, that isn't just going to kind of swoop in and handle one dispute, can make all the difference in the world. Modern HOAs, as I'm sure all of you know, your rules, regulations, your CC&Rs, we can talk about hundreds of pages of documentation that govern how your community is run. And every community is going to have individual nuances. There's going to be that inevitable sticky wicket neighbor. There's going to be that person who shows up at every board meeting and wants to voice a grievance. A neutral who's willing to get to know your community and understand the unique problems that it has will be able to more effectively resolve a lot of these problems. And if you can get them involved to be proactive, you can stop a lot of these problems before they actually materialize. 159. How'd I do, David?
You're right on target. So
there we go.
All right. So that's good. So thank you so much, Jonathan. Appreciate your time and the presentation. At this point, what I would like to have is our members to ask them to go to the question and answer, the Q&A feature, and make sure you put your questions in there if you have questions, and also to vote. So use your thumbs up. Here's the thumb right here. It's in the corner of your, sort of in the corner of the other corner of your screen, and vote so that we can prioritize. Jonathan, for your knowledge, up in the right-hand corner, you push the the caret down, it says most recent, and you'll find it says most upvotes as well. Select that, and then you'll be able to go, be able to see the questions. And we'll probably start from the beginning and work our way down with the most questions. And looks like we have 6 for one of them, so that's good. And so anyway, I'm going to get us set up here. All right, so we can go ahead and get rolling. I want to say thank you to everyone for participating today, and to our question and answer sponsor, if we have one. And all right, let's go ahead and start with question number 1 up here with 7 thumbs up or 8 thumbs up. What can be done if the HOA secretary's meeting minutes do not state what happened at the meeting, and emails disprove the HOA secretary's statement, i.e. the board's position is that it doesn't get involved?
Right. So this is one of the many reasons why I think communication is so important. And it's also why I like the idea of having dedicated neutrals for communities. Because this, probably more than anything else, is the sort of situation that leads to lawsuits. When people don't feel they're being listened to, or when you get a reaction from a property manager or a board that says, you know, we're not addressing your question, that has a tendency to irritate people and tick them off, and make them seriously ponder escalating the dispute. Hopefully not through court, but it often goes there. But the only real way to address problems in your HOA is to talk about it. Fundamentally, communication matters more than anything else. You can go to court and you can ask a judge to decide whether or not the HOA has taken the correct position, that it does not have to get involved in the accuracy of meeting minutes. You could, in theory, file a lawsuit about that and ask the judge to resolve it. But as I hope I demonstrated with the One Ford Road case, and I'll give you a little bit more nuance to that case to illustrate this point, that case came down to a single clause that everybody was fighting about in the CC&Rs. But the HOA actually won that case at the trial level. The trial court said the HOA was right and that the homeowners did act unreasonably. When it got to the Court of Appeal, the Court of Appeal said no, the homeowners were right and the HOA was wrong. So you can give me just about any dispute, and I can probably envision a situation where when you take it in front of a judge or a jury, either side could win. The only real way to solve these problems is to have an HOA board that is open and receptive and listens to members, and for members to stay engaged.
Yep. Okay. Sounds good. Here's the next question with, let's see, I think we have 10 votes on it. So what is California's law about recording ADRs and IDR sessions? During the scheduling of my HOA stated session would be recorded. They stated that it would be recorded. However, when I asked them if I could record it, the HOA suddenly decided that they didn't want to do the recording. So what's the I assume IDR and ADR might be a little different, but
yeah, ADR and IDR are different. But if there is a mediation that is occurring under either IDR or ADR, because technically that's possible, the mediation is confidential. And California law is extremely strict about this. Whatever goes on in mediation literally stays there. Someone in a mediation could admit complete guilt and liability, and that cannot be used later on down the road, even if a lawsuit is filed. And there's a good practical reason for that, because in mediation, the law wants to encourage people to be open, and they want to encourage communication. And the hope is that that blanket of confidentiality will help people speak freely and not be so reserved or worry that they're going to say something that could come back to bite them later. So if there is a mediation, it absolutely is not getting recorded. If there is an IDR session that is literally just sort of a meet and confer or a letter writing campaign, I mean, that's effectively capable of being recorded. I can't imagine why you would want to, but I can envision a situation where IDR could be. but I would not recommend it.
Yeah, isn't it? I think maybe the question goes to what's good for the goose is good for the gander. Is that kind of the way it works?
I think that's what the question's driving at. I mean,
Yeah.
the way that question is worded, I almost get the impression that the HOA probably realized that they couldn't record a mediation and said, whoops, my bad.
Something like that, yeah. Okay, well, without knowing the specifics, that's the answer. It's a good one. And the IDRs are a little less formal than the ADRs, and so that's kind of the other thing. Here's the next question from Mr. Anonymous. 9 upvotes, or Miss Anonymous, maybe. Who would participate in an IDR where the plaintiff is a board member and the defendant is another board member and the management company? So that's kind of an interesting dynamic.
Yeah, that is an interesting one. And that's exactly the sort of situation where I would recommend bringing in a third-party neutral. I mean, I don't think that the board would be in a situation where that could be properly addressed and anyone could feel like they were getting a fair shake. In fact, even if it's just a member talking to the board, there's frequently a bit of distrust about whether or not the member will actually be heard. So bringing in a neutral in that IDR context is the only way I can see anyone feeling like they were going to have any hope of resolving that kind of dispute.
Yeah. Well, I think the first step is try to sit, if you're both board members and you got a management firm, try to work it out before you even get to the IDR ADR process. But if you can't,
that's absolutely the way that you should try and approach every problem. Yeah. Do we really need IDR? Can we just figure this out?
Okay, I get that. Craig Yates says, and he's got 7 upvotes here. Why will HOA attorneys tell HOA boards not to activate a Zoom meeting recording feature? I think.
Yeah. In all likelihood, it's because if they record that meeting, they are effectively documenting verbatim the minutes of the meeting. And if you are going to record a meeting and you're going to preserve that recording, which at the moment you start recording it, you probably have an obligation to preserve it, then that record is available for anyone to view. You can go into the wonderful Davis-Sterling Act Civil Code Section 5200, and members can request minutes of board meetings. And if you're going to record the meeting, that's effectively the minutes that members can then request. So that would be my guess, but I have no idea because that's an attorney-client privilege communication, and I'm not their attorney.
And you know, the color, adding all the colors in the conversation is not necessarily going to get you to the right endpoint anyway. So
yeah.
Most of the minutes should be very, very factual and very small, short. They should not be, what actions were taken and that kind of thing. You don't want to, get too far along on that. Okay, here's the anonymous attendee again. And we had seven upvotes for this one. I am an HOA board member, discovered various violations by the board and manager, i.e. falsified minutes, missing special reserve accounts, overspending, unnecessary projects, conflict of interest, et cetera, et cetera. I prepared an IDR, followed the procedures 30 days and went through prepared IDR 30 days and came and went. They ignored the IDR. I sent the IDR number 2, number 3, number 4, all the other violations. So they're trying to get some resolution here. They stated that they had no defense and continued to violate the CC&Rs. The board hired an attorney who authorized the IDR procedures to send me a dozen threatening and harassing letters, according to the writer, and to send me those threatening and harassing letters with threats to sue for an unknown reason. I professionally responded to every letter asking the purpose, no replies. IDR procedures clearly state if either party hires an attorney, they do so at their own cost. Over $15,000 has been billed and paid by HOA assets, which should have been paid by HOA board members, by the board members. I have been denied access. So this gets pretty specific. I think you need to talk kind of a little bit overarching wise. And answer this question.
Yeah, my answer to this question is this sounds like something that you need to consult an attorney for. I'm not here to give anybody legal opinions or advice, and this question is asking for just that. You've got a very specific situation that clearly is going to require some investigation. The only thing I can recommend is if you had a mediator or an ombudsman that was specific to your community, it would certainly make it much easier to feel like you had some additional oversight. Ombudsman can frequently be seen as the conscience of an organization. So if you're looking for a conscience, that's something you might want to explore. But this question requires a private conversation with an attorney in confidence.
Yeah, so I'm not an attorney, but I'm gonna throw in a couple of thoughts. First of all, if you're doing the IDR, you can go to an ADR, and start the process of an ADR. The most important thing here is to document that you've been doing all these things and what you've done, and then you have that down. Sometimes the only solution is to go to court, and so that's what you need to ask your attorney. Okay. Let's see. This is from anonymous attendee again. 8 thumbs up. IDR Civil Code 5915B4. The parties shall meet promptly. My HOA's idea of prompt is to acknowledge my written request right at 30 days to actually get the meeting scheduled with the board member is about another 3 weeks on top of that. There isn't a definition for prompt, but what is reasonable and how can these delays be prevented in the future?
One of the most frequent questions that I get, and one of the most problematic things to try and fix, because the reality of pretty much every HOA board decision is that it has to be made with the board in the context of a meeting. So if you have a problem that is going to, present itself the day after a board meeting, you're going to have to wait until that next board meeting for your HOA board to actually even ponder the problem or ponder your request. And then they're going to have to vote on it. And then they're going to actually have to make a decision about how to respond. My point being is that as crazy as it seems, that is actually pretty prompt. That's within the guidelines of how most HOA boards operate, because they can't make decisions without getting all the board members together and having a quorum. So it's almost a necessity. The reality is, though, nobody wants to hear that, and nobody wants to wait around for it, and nobody wants to have the property manager say your complaint has been received and will be addressed at the next board meeting. And it's another reason why I encourage retained neutrals, ombudsmen, mediators, folks who can operate with confidentiality and who can be a resource for helping members navigate these sorts of problems so that the members don't have to wait for 30, 60, 90 days for the board to get all of their corporate formality ducks in a row. But you're right, there is no definition under the law of what prompt is. It just says prompt deadlines, at least within the context of IDR. ADR does have some deadlines attached to it. But even for ADR, you're at about 90 days. So if they're getting back to you within 30, they probably have a good argument, at least to a judge, that they're being prompt. 30 days is a good turnaround for a lot of HOAs, as horrible as it is to say.
Yeah, and the code for the ADR process. So you're ratcheting it up from an IDR to an ADR with a little more restrictions on the ADR. That code is 5925 if you want to reference that. Look and see what the requirements are there, because you can go from one to the next and then decide where you go from there. So there is a process. And the other thing I want to say, and I don't know if you touched on this, Jonathan, but sometimes governing documents have alternative, they have this conflict resolution strategies in the governing documents, right? So you need to check your governing documents and see what those are too, because I believe those take precedence over the other ones, especially if they're more restrictive, right?
Correct. So the way that the IDR process in particular is set out is there is a floor. There's the minimum requirement. But HOAs also are required to publish in their annual disclosures the IDR procedures that they have adopted. So if they've ramped it up and they've gone above the minimum requirements for what the law requires, then that is going to control. And if there's something in there that says they need to give you a response within 30 days and it's a self-imposed rule, then there you go.
Yep. So there you go. And so next, these are long questions, so I'm going to try to get through them. We only have 5 minutes left here. My question is how one ex-board member can obtain information about a legal bill that was acquired during my term and now is an issue, but I am not part of the board. I resigned to obvious. Yes, I don't know what that means.
Avoid, maybe?
To avoid escalating. To my surprise, the manager and new board hired an attorney at $9,000. How can I request more information about that? And what do I have rights?
So it sounds like you do need to consult your own attorney about it, but you do have, and I'd encourage everybody to go to Civil Code Section 5200. You can go to davidsterling.com and pull it up. And there are literally like 24 categories of different documents that you can request from your HOA. And HOAs these days have digitized so much, a lot of it's available online. But you can request more information. There are mechanisms for it. And Section 5200 is the most cost-effective way to do that if you need more info.
Yeah, so that's 5200's record inspections. So
Yep.
Okay, so next one here. What is best to do when a board member number one will not talk to board member number two, even though board member number two has reached out to talk to make herself available? Silence and avoidance is number one's response. The board member number one is talking to members about it, but not fellow board members. What do we do? So a little passive aggressiveness, huh?
Yep. Good old board dysfunction. I mean, one of the things that continues to motivate me to try and encourage everybody to bring in neutral third parties is a lot of these HOA disputes can end up looking a lot like a family law dispute. You know, when you live next door to your board members and when your home is such a fundamental component of the dispute, people can get very fight like caged rats sort of mentality, and they can do all sorts of things that can either be dismissive or employ some of the less effective negotiating strategies when they want to achieve their goals. So in my experience, bringing in someone who is a neutral, whether that is a member of your community or whether it's somebody that your community has hired to inject themselves into these kinds of situations, is really the best way to get everyone to stop thinking about their individual situations and start thinking about the community. As what you've described in this question is two folks who have decided that one of them's decided they still want to have a conversation, but the other one shut down. And that other person needs to have a change in perspective. There needs to be a shift. And it's very unlikely that anybody that they know is going to cause that shift. Like when I'm fighting with my wife, we both know each other well enough to know each other's tricks. 15 years have given us enough perspective. And in this sort of situation, you probably need to have that community mediator in order to try and break the tension here.
Yeah, well, I celebrated 42 years yesterday, but I still don't know.
So. Yeah. My wife knows how to play me like a fiddle, so she's
okay. Okay, so here you go. So here's an interesting one. I hear a lot of this. So the association sends a letter to notify a member of a potential violation, but the member who raised the issue in the first place, talked to the board and said they're violating something, doesn't want to get involved. What's the board? I mean, what's the board to do?
Wants the board to handle the issue as a rules violation.
Yeah, so they violated the rule, and so well, does the issue then become a meet and confer between the potential at fault member and the association? It's a rules violation. If somebody's violating the rules, right?
It sounds like this is like 3 different people. Sounds like there was a complaint raised to the board.
Right.
And so you've got 2 members, and one member basically doesn't want to confront the other member about it and has gone to the board for assistance.
And said, you deal with this board because it's a rules violation.
Right.
Yeah. And so they're sort of punting as the board. So what do you do about that? And the other party, the initial complaining party, doesn't want to get involved.
Right. So
they have by definition gotten involved, right?
Right. And that's the problem. Boards put themselves in a very sticky situation when they do things to try and satisfy an aggrieved member of the community, and unfortunately end up dragging other members of the community into it. It is not a good position for a board to be in. But you do not have to use the board, and if you're on the board, you do not have to be injecting yourself directly into the dispute. You can request ADR and IDR between neighbors. It doesn't have to go through the board itself. And if the board doesn't have a dog in the fight, I would not inject myself into that fight. Stay out of it if it's truly a neighbor dispute.
But if it's a rules violation, that they do have a dog, right?
If it's a rules violation,
yeah.
And here's what I'm kind of driving at here, because the way this is phrased is that it's a potential violation. Okay. And having a potential violation versus an actual violation, and I've seen this before, is a problem. Because if a board is sending out a violation notice saying you may be violating the rules, you're going to get everybody hot and bothered real quick. And then if there isn't an actual violation, then you're prompting that member that you sent the notice to want to take legal action against you for giving them a hard time. And then you've got the member that you sent the violation out on behalf of who's going to be ticked off because you didn't find the violation they hoped you would find. And it just goes round and round.
Okay.
Yep.
All right. Well, yeah, I think and that's probably more specific. So I'm going to kind of go through some of these shorter ones here. Real estate law requires that you disclose these problems to the HOA community so buyers are aware of HOA problems. Is that right?
So there is a whole separate section in the Davis-Sterling Act that requires disclosure of all kinds of different things when you are buying a property in an HOA. But it is going to usually be limited to the individual issues with the property. So if there is a lawsuit related to the piece of property that you are buying, yes, you will find out about that. If there's some sort of tangential litigation going on in the HOA because somebody tripped and fell in a common area, that has the potential to fly under the radar and not get disclosed. So yes, you are correct. There are disclosures that are required, but believe me, lots of people file a lawsuit because they feel like they have not been given full disclosure, and they want to go ahead and fight about that in court. And then they drag their real estate agents and realtors into it, and then it gets real fun.
Yeah. So that's interesting. And we got a lot of questions about that. We have a lot of questions still remaining, and we are actually over time. I would like to go ahead and do the closure here, and if you have a couple minutes, John, to stay a little longer, how's your time?
Yeah, I can stay around until about 2:30. I budgeted for that. So
okay, till 2:30. Okay, well we'll be done by then. So I'm going to go ahead and we're going to have to close this. Connor and I will stay a little later and answer what we can. Okay, so here are the concluding remarks. Q&A is over. I want to say thank you to all the ECHO members who came today and for supporting ECHO. We appreciate everything you do in support of our philanthropic cause here. For those of you who are not ECHO members, please consider becoming a member and supporting HOA boards throughout the country. To join, simply go to www.echo-ca.org and click on the membership tab. For ECHO members, thank you for supporting us, and please invite your friends, boards, and especially management firms and vendors to join ECHO. A simple invitation is often all it takes to encourage someone to join. If you would like to become more involved with ECHO, we have a few opportunities for you presented on the slides next to us. Just drop me an email at dzapponi@echo-ca.org. And now for a few announcements. These are our small group meetings around the state. We have a new South Bay Resource Panel in San Jose on October 24th from 11:30 a.m. to 1 p.m. And they are going to be discussing landscaping and landscape maintenance at Heritage Bank of Commerce. November 7th, Orange County Resource Panel will meet somewhere down here. We're finding a location, and we'll get back to you on that if you happen to be in Southern California. The new San Francisco Resource Panel will also be held on November 8th. It'll be from 5:30 to 7:30 p.m. Rachel Miller and Alex Noland, two attorneys from the San Francisco market, are going to talk about water intrusion and who's responsible. Water is the #1 claim that insurance companies have. In San Diego, at the San Diego Resource Panel, we have a meeting on Saturday, November 11th, and they're going to talk about finding insurance that's right for you and your community. So a lot of folks are having issues with their insurance now. The next ECHO's Board Members Club meeting is November 14th. It meets via Zoom every second Tuesday of the month from 5:30 to 7 p.m. and it's open only to board members or former board members who are ECHO members. Once again, I want to say thank you to our sponsors for making this community conversation possible, and thank you to John for developing and presenting the materials you saw today. And of course, thank you to all of you for attending today and making this a successful event. ECHO appreciates your investment in education to foster a better quality of life in HOA communities.